Senator Ward, you're up next if you want to put your questions to the Dr. Ryan and to Ms Dixon.
Thanks very much, Chair. My questions primarily are for the Data Protection Commissioner, and I welcome her and I acknowledge that you have a very difficult position. I noticed that in the report, the annual report, you referred to 2020 as being a platform or a stage for moving forward. So I acknowledge what you've said today as well. I also welcome the fact that you've said that data protection is not an absolute right, and I think very often it's used by officialdom to stymie things rather than to allow things to proceed. So I welcome that attitude towards it. I wonder if I could ask you, Ms Dixon, about, I suppose, the compilation of databases and whether or not you think it's legitimate for any organisation to take a number of publicly available and legitimate databases to consolidate them together and then to create a super database that may be used to extrapolate other information from it. And that being the case, is what rights are afforded to individuals to know essentially whether they're on that database, what information that has about them, and what information maybe it has extrapolated about them also, and what remedies are available to them in terms of obtaining that information, or any maybe predictive scores or trends that might have been identified.
Thank you, Senator. Okay, very good. And I think that question was directed to Ms Dixon. I might just ask the questioners as we go through the remainder of the session, maybe identify which, if you're direct question of check a witness, maybe just indicate that. So, Senator Ward, I think that question is to Ms Dixon. So, Ms Dixon, if you'd like to answer.
Thank you, Senator Ward, for the question. It's interesting. It's difficult. We're talking about a hypothetical scenario. It's difficult to imagine what legal basis any data controller would have to create a centralised database from varied sources without the knowledge of data subjects. And so the first question to be asked is, what's the legal basis for the creation of the database, the procuring of it from other sources? Under Article 14 of the GDPR, if a data controller obtains data indirectly, so not directly from the data subjects themselves, they have an obligation as soon as possible thereafter to inform data subjects. So typically that would be an obligation on them. Earlier, Fred Logue Associates referenced also Advocate General Bobek from a regas case from the CJEU from 2016. And that's actually a case where, in his opinion, the Advocate General said that it's these large data sets that are of primary importance and the primary purpose of data protection law and the reason why it's of primordial importance. So I'm not sure what's behind the hypothetical scenario you present, but it would certainly be of something that would be of interest to us as a regulator in terms of how it could be compliant.
Okay. Chair, do you mind if I follow up briefly on that?
Because you didn't get in the first round, I'm going to indulge you in this second question.
I suppose I'm thinking in terms, let's say, of electoral registers that are legitimately available, but there might also be copies of marked registers that show whether a person has voted, and they can go back a large number of years. So consolidating them together obviously compiles a huge amount of information about voters, and I'm wondering if it's legitimate for that information to be brought together without the knowledge of those voters, and maybe for extrapolations to be made from that, including, for example, voter intent, or predictive scores about how people might vote. I'm wondering, is there a legitimacy to that? And if so, is there an obligation on the data controller to inform those persons on that register, and what remedies are available to them in the event that maybe there is a shortcoming in respect of data protection obligations?
Thank you, Senator. Ms Dixon, if you'd like to answer that question, then we'll move on to the next, but you can answer that. Thank you, Ms Dixon.
Yeah, so again, you'd have to trace through all of the principles of the GDPR and examine the 2018 Act. So clearly there's a very specific context if you're talking about data that's collected and compiled for electoral activities, and there is provision in the 2018 Act. It's not a free-for-all that allows for it. So you would first of all have to look and see, does that provision create a legal basis sufficient for what is actually taking place? Secondly, that provision doesn't eliminate, as you said, the obligation on any controller to ensure transparency in relation to data subjects, and to ensure that those data subjects are going to be able to exercise all rights that may be relevant to them under the GDPR. So it's not possible to give a definitive answer because, again, the devil is going to be in the detail of how it's done. It's theoretically possible to legitimise it. Equally, it's possible that it would fail in actual implementation on every single one of the principles. And so it would be important to step through it in the actual detail in order to answer your question definitively.
Thank you, Ms. Dixon.